areas of taxation. Michael advises on transactions and structures, as well as investigations and disputes with HMRC. And he really is an expert, as he's in court day in, day out, and the tribunals as well. So today, the webinar is going to focus on HMRC, due diligence and supply chain on umbrella companies, acquisition accounting, and mini umbrellas. I think as a lawyer, I can vouch for all of the lawyers in this webinar today that we want to help you to try to be ahead of the curve by making sure that all your procedures are in place and up to date, so that you're proactive rather than reactive, to enable you to conduct your business as effectively as possible. So we hope the next 45 minutes or so will be really useful for all of you. If you have any questions you'd like to ask, please put them in the Q&A at the bottom of the screen. And after the presentation is finished, we will try to answer as many as we can. Pandy, if I can hand over to you now.
Thank you so much, Sonia. Thank you for the introduction. Very much appreciated. And may I first of all say welcome to all the attendees here. Very good to see the names on the participants list. And also very good to see, as Sonia said, some of the returnees from our first webinar last month. And webinar 2, as you know from the title, will focus very much on HMRC investigations and looking at due diligence broadly, with a view to seeing what are the tips and guidances, pitfalls, and what are the areas that you really should look out for from a practice and procedural point of view. But added to that, how does it work from a real legal and regulatory point of view? And with that in mind, I'm absolutely delighted to have Mr. Firth with us from Grays and Tax Chambers, and I'm really grateful for his time, and really appreciate that he was able to join us today, with such a short notice from the last couple of weeks when we've been speaking to Mr. Firth. So thank you very much for that. What I have a short presentation in relation to HMRC investigations and due diligence. And of course, I'll be looking at it very much from the perspective of a legal analysis as opposed to a practical accountancy-based view. And as you can imagine, this is a webinar and not a legal advice forum per se. And as will become clear, it is essential when one looks at due diligence, what sort of practical things that you must do. So with that in mind, what I was going to say to Mr. Firth is please, do jump in as you feel like, or if you want to wait till the end of it, please do. We have got about half an hour slotted in for the presentation, and I'll try and do mine in about 20-25 minutes. Then hopefully I'll give you extra time needed. Otherwise, please interrupt as you feel appropriate. So I'll start my slideshow from the beginning, and then if you just bear with me 1 second, I will do this. Thank you. So as I said in my introduction, so today is really going to be focused on due diligence and supply chains. And as Sonia introduced, I do specialize in asset recovery, tax, and proceeds of crime. But of course, we advise regularly on all the regulatory agencies that would be interested in this matter, or particularly tax-related recovery involving employment agencies and recruitment agency, in particular payroll sector, such as HMRC, National Crime Agency, Home Office, and GLAA, to name a few. And of course, next month, we will look at GLAA and what the due diligence from their perspective would be. And for some of you who attended last month, we were looking at it in broader terms. The HMRC investigations today is going to be very much on due diligence, and next month will be on GLA investigations, employment law, and how that relates to the regulatory scheme. And then following on that, in March and April, we'll be doing our third economic crime conference, particularly focusing on money laundering and tax evasion, which is a key topic at the moment, with so many different areas of law being covered within that scheme. Now, what we're going to talk about today, I really look at it very in broad terms, what is expected of due diligence, particularly in supply chain scenarios, then look at just some three particular topics or the schematics of available sort of schemes at present. When we look at standard umbrella companies, acquisition accounting, and mini umbrella companies. And thirdly, to look at, and I think this is where really is what, many of you attending, I hope will want to really think about this, the auditing and the reviews, is to see, what does the regulatory landscape requires you, asks you, and expects you to do from the scope of auditing and reviewing and continuous due diligence. So starting with HMRC, many of you will be very, very familiar with this. And HMRC are very, very clear in their stance when it comes to supply chain, when it comes to multiple transactions. HMRC expects you to undertake detailed three-step layered process. And I think the vision, the ethos of HMRC request, in my view, can be summarized by this particular passage or paragraph I have taken out from HMRC's due diligence guidance, because I think this underpins what happens or what is expected of companies in payroll sector, employment agencies, recruitment agencies, and so on. And this is what HMRC states. Failure to perform reasonable due diligence checks can lead to significant issues in terms of legal, financial, and reputational risks to businesses, and potentially prevent the business from operating in its entirety. So it's really important you identify what checks you need to do and how often you carry them. You must make sure that you keep a detailed record of all checks made. And with that little scope of what is expected and what is the importance of it, you can look at the three-layer process that HMRC asks you to do as an responsible individual, as well as a responsible director or a company, which is to check and make relevant checks of your supply chain, act on the information that you've been able to gather, gain, obtain. And then thirdly, of course, is to review, analyze, and to see how that can really fit within your business, within your model you're operating, and how that actually is in compliance with HMRC status in terms of non-avoidance of tax, and in terms of making sure full compliance, i.e. don't fall into the non-compliance basket. And when it gets into the non-compliance basket, you then get into the elements of fraud and other irregularities, which of course, you want to avoid from day one, which can be done if you go through those three checks. Now, what are the sort of the checks are we actually talking about? And I think, again, a lot of it is common sense. When HMRC investigations looks at you, and of course, I've given a name of a company they're looking at, Rishi Dishi Rwanda Payroll Limited, for the sake of argument. The point is, when you look at a company, these are the things that you have to think to yourself. How did I identify my supplier? Why did I choose that supplier? And what sort of audit and review am I going to take? So when one looks at Rishi Dishi Rwanda Payroll Limited, where do we go for that? And I think obvious for most people, Google and open source is a fantastic starting place. You really have a lot of information that you can gather and you can look at to see, well, actually, does this company actually exist? As a good starting point. And where do you look at that? Companies House is the starting point. And I can tell you this company does not exist because, of course, I made it up. But that is a simple position to start with. Does the company exist? What sort of a history does the company have? Has it ever been involved in insolvency issues? Has it ever been subject of a liquidation? Has it ever been subject of any form of insolvency procedure? And then you can also look at real company due diligence, can't you? You can look at credit reports, you can look at CFAs, you can look at other material which you can actually get it directly from the company itself. And I think often in a sector such as payroll or in umbrella companies and mini umbrella companies, often people go to references, recommendations, industry knowledge. Has anybody ever heard of Rishi DC, Rwanda Payroll Limited? And the answer, of course, is going to be no, and it should be no. So I think industry knowledge cannot be underestimated. And then if you're looking at it from the standard umbrella company point of view, you have to ask these basic questions, don't you? How did you come across the supplier? How were you approached? You might think, well, Mr. Ganesan, that's very, very obvious, You might say, well, actually, I got a phone call, I got email, I got LinkedIn, or Zoom calls, or even a webinar where I got, met up with somebody. Whatever it is, what is expected of you? And I think this is the key thing to remember. Keep record of the approach that has come. And I think that is so simple, but I can guarantee you, and I'm sure Mr. Firth will add to that, the number of cases that I have done, both criminal and civil regulatory tax based, where these initial elements just completely missing. And it's, the value of it cannot be overemphasized. And if you met them, how did you meet them? Where did you meet them? Was it in print? Was it in a formal settings? And if you did meet them, the best way to do is to have some contemporaneous records to show that this actually happened. Send an email. And your colleague, if he responds, or he or she responds, then you have got a time-stamped communication to demonstrate you met this person in this place. Keep a good diary of the meetings. Keep printed copies. Well, of course, we all work digitally. You don't have to have printed copies, as long as it must be available, it must be obtainable, it must be reachable. And often people have the difficulties. Sometimes things get archived, sometimes things get destroyed, sometimes you lose data because of computer problems. Then the next question is, look at the company. How old is the company? How many directors does it have? How often does the directors and secretaries change? Has the company changed its trading names? How many times has it changed? There is so much information available publicly about companies. It only takes a few minutes to actually sit and analyze that data. And when you see that if there's a company that is only set up, let's say for the sake of argument, last week, but the company is now suddenly looking to do millions of business and doesn't have any trading history, you might want to think about that, wouldn't you? How valuable, how commercial, how accurate is the information that's being given to you as the potential supplier? And the key question is, why did you choose the supplier? What are they actually giving you? And what commercial factors can you take into account? Often people say, well, actually, I'm a small company. I can't afford to have the type of things that a bigger company can have, which would assist with taking care of all the regulatory and other practical considerations, whether it's financial, whether it's human resources, whether it's setup costs, whatever it might be. So therefore, if I can outsource it, I do obtain a credible, a legitimate benefit from that basis. And of course, often, these are really good, valid reasons, right? From a commercial advantage point of view, lack of resources many companies have, a lack of expertise. We often have that, well, Mr. Ganesan, I'm not good with employment law. I don't really understand it. The working time regulations are difficult, off payroll, or, travel allowances, etc. I need help with that. Or often people don't have the actual setup within the department, such as software or other facilities which would allow that. And of course, it's all about economies of scale, isn't it? When you're a small company and when your profit margins are small and you're trying to do things properly, sometimes getting outsourcing help does work. But the key is it's also a factor that allows you to have mitigation in terms of risk as well. because you have got somebody who knows what they're doing, they have the proper setup, they have the proper knowledge, they have the expertise and the computer basis and so on. Now, once you do get past identifying a particular supplier, then you do look at the company, don't you? And most people do this. But the question is not do they do it? Can you demonstrate that you have done it? Can a verifiable record be obtained and produced when HMRC asks, or when your legal or accountancy officers ask you for that? And these are basic stuff. Corporate checks you can have, company registration, we talked about that just on Companies House, director identification checks. How many companies is this person a director of? And I have had cases where one or two people in a particular case have been directors of 35, 45 companies each. And there's a lot of companies to monitor. Look at the VAT status, look at live check, look at PAYE, look at their current PAYE position, current VAT position. And these are vital checks that you need to do to ensure that the entity that you're dealing with is in fact the right entity, and is for the entity that is commercially viable. That's the entity that is not going to disappear in 1 or 2 months down the line after the debts accumulate, or after the VAT or the PAYE, NIC, whatever it might be due, And we already mentioned the open source checks, which you can do, Companies House, and often nowadays you have company reviews. People are very, very good at putting forward when companies do their products and services. Look at customer complaints, And of course, there's a lot of other information available, like list of defaulters, DDoS scheme. When you do it, a good tip is to take a screenshot and look at it and see, whether this can be filed electronically. And we already mentioned the quality issue. Quality aspect comes from recommendation. Recommendation of certain person is an expert in this field, like we're talking about tax and supply chain and HMRC investigation. Look at other customers. Can you legitimately get a reference from the customer? And industry knowledge is very, very important, as we already mentioned. Added to that, and I think it's critical, and HMRC expects you to do that, look at the contract. And what does the contract actually say? And does it actually have right level of basic contractual agreement? Obligations of the parties, mutuality of obligations. Look at, does it have right level of work and services being provided? What are the hallmarks of that contract? And more importantly, who is the person that's going to be responsible for payment of taxes, especially when one is considering supply chain, when you're considering a number of different parties to a transaction. And the contract, you'll be amazed, I have seen contracts that are very detailed. I've also seen contracts that are 2 or 3 pages when dealing with multi-million-pound contracts and multi-million-pound transactions and multiple transactions. And you might say to yourself, from a HMRC perspective, well, hold on, you're a company that's doing a large turnover, but can we actually look at what you do and what is your relationship with your supplier? And does it actually make sense? Does it make legal sense? Does it make accountancy sense? And does it make regulatory sense from a commercial point of view? Another model that I see quite often nowadays is one acquisition accounting. I don't know how many of you have come across it, but this is something that a couple of my clients have raised it, and the way it seems to be, again, this is just in generic terms I'm talking about. I'm not talking in one particular company or an issue, but it seems to be a new form that's arising in terms of the market availability. It seems like it's currently prevalent, and it's talking about offsetting of taxes. And the way that has been described to me, where you got a number of companies in a group structure, where you got company A, B, C, owes taxes to HMRC, whether it's a PAYE, NIC, then you have a final company on D or EF, which has got credit or a refund. And it seems to be the principle is it's using one company to offset tax liabilities in other companies, whether it's A, B, C, or D, F, whatever it might be. It seems to be a group structure based model that seems to be arising. And you, of course, when you look at HMRC and HMRC point of view, no doubt you would have to do due diligence on all of the companies, don't you? You can't just simply say, well, I'm only going to do one and ignore the rest. So you certainly would have to do diligence all of them. I suppose the basic questions that, from a legal perspective, I would be inclined to know and to answer as a company director as well. How did the tax position arise? Where is the tax position? Show me the proof of the tax credit position, both debt and credit. And what are the additional stuff that you would need to look at? As I said, you can't just do it on one company. You got to look at the whole supply chain, because you may have a number of different companies. And the other thing for you to really think about, and if you are involved in this, is to say, well, if you already have 2 or 3 companies that are effectively failed businesses or subject of liquidation or subject of other insolvency procedures, then you will have other professionals involved in it. You will have insolvency practitioners, official receivers, potentially trustee in bankruptcy involved, and so on. And of course, you want to know how far these debts have arisen. How old is this debt? And you need all the disclosure from these companies. So in my view, this particular model does raise a lot of questions. And if you are a director, if you're a person involved in this or considering this, of course, my very strong advice is think about it carefully and see where are the challenges arise. And if you are the director who's knowingly or willingly entering into these sort of models, you really have to look at where does your liability sits, not only as a company, not only in terms of paying for the VAT and the PAYE and the tax positions that are due, but about other things in terms of joint and several liabilities, in terms of, am I turning a blind eye? What are my obligations when looking at the reality or potential value of a model that you're looking at? So in relation to this model, my strong advice is caution must be exercised. Need to consider, is there a legal and accountancy basis for this? Certainly in my little research, I'm sure Mr. Firth will correct me if I'm wrong, I haven't found any evidence, at least I haven't seen any consideration by the court or in any assessments in terms of the longevity or the ability of this particular model. Clearly, this is a model that no doubt, if you're looking at it, you need to really take an independent legal advice, both legal and accountancy. And as I said early on, we're not giving legal advice here. This is a webinar, nothing more than that. But really is, you need to consider very carefully, what this model is and how does it work in practice. And of course, I'm capturing all of this from the point of view of HMRC. These are the questions that HMRC will be looking at. And that's the questions that I think we must really consider. And I'll let Mr. Firth come on to that in a bit, unless you want to jump in now.
I'll wait till the end.
Thank you, yes. And the other company, other format of company that I wanted to touch upon was, of course, is the mini umbrella companies. Again, many of you attending here will be extremely familiar with this. And of course, HMRC have a very much a disruption policy attitude towards many umbrella companies. There are plenty of documents available, plenty of information is available, so I don't want to waste anybody's time on that. But it is important to really ensure, from a due diligence perspective, look at the supply chain, make sure you go down the supply chain, look at the obligations of the companies that are involved in it, make sure what are the current position of PAYE and IC, look at the VAT position, look at the VAT procedure and supply chain within those, and you might say, well, hold on, that's very, very difficult to do because there may be a number of different companies on it and I'm a very small provider. But the point is, from a HMRC point of view, again, I go back to what I said earlier. When the HMRC investigation comes, you must be able to demonstrate, you must be able to produce, you must be able to show that there has been thinking behind the due diligence. And the best way to do it is if you can show a sample of it, even if you can't do every aspect of it, have a good, proportionate, rational sample. which you can, of course, to show to the HMRC that there has been a real consideration in relation to that. And of course, take good accountancy support. Make sure you take legal advice. And I cannot say the importance of that. What are the other things that you can do, which is the third point in terms of check, act, and review? And there's a third one of HMRC. What they ask you to do is continuous due diligence. Look at live check VAT every month. Ask for proof of current pay-away positions, RTIs and payslips. Ask for proof of VAT. You could look at the revenue portal and look at HMRC and the black points. I'm sure many of you will know if you're late with filing your returns, you do get points nowadays. And look at reconciliation and look at, are there any products that can help you to make your due diligence, make your checks, make your reconciliation better. I'm not advocating for any particular software or a product. I'm not here to advertise, but I have come across SafeRec is one of the products I've seen, but also there are many other products which also help with payroll, with help with reconciliation. I know many of you will know Xero and Sage and so on. Okay. Always look from a HMRC point of view, proof. Where does the proof lie? And how do you prove that? And as I say, take screenshots, take printed copies. I know it's not a good thing to do from an environmental point of view. If there are some of you will still want to make sure you have it, back up offsite. And that deals with any cyber attacks, that deals with any malicious ransomware and so on. And have proof and make sure you review that continuously. And I think that's the most important thing, And continuous review includes looking at the whole structure, looking at the supply chain. And as I said, when you look at the contract, what does the contractual arrangement actually say? And if you're not sure, get advice. Because as I say, some contracts are very lengthy, very detailed, very legally orientated in terms of language. And you may wonder, well, actually, is that what actually correctly reflects what I am doing? And is there any risk me and my company and my supply chain, my work is being used improperly, is being used for ulterior purposes? And of course, always remember joint and several liability. Do I really want to be at the cold face of having to deal with real tax liabilities that's gone wrong in the supply chain? Again, what is the basic things that you should do? Have a good quarterly independent review of your processes, auditing, monitoring, review the systems, review checks and balances. And often it's good to test your due diligence. Is this actually working? Is my due diligence as what HMRC would want to see on the first slide I showed? And is it in a position that I can actually defend? Am I able to actually produce documents to convey to HMRC that my systems, my processes, my checks and balances, and whichever model that you're looking at is actually accurate and in a workable condition? And I think the other things that we have already touched upon at the last seminar, just a reminder, really, there's a lot of documents available in terms of tax avoidance schemes and stop notices and promoters and so on. I don't need to touch upon that, but what we don't want to do that is end up being in a scheme, whichever scheme it is, whether it's new and untested or whether it's an old and tested. You do not want to be ending up in these sort of publications. So with that in mind, I'm going to stop now, and then I'm going to let Mr. Firth come in.
Thank you very much. I mean, what I would do is echo what we just said, and perhaps emphasize a few key points that I have seen from my own practice. So what I would emphasize in particular is have a policy, have a due diligence policy, so that when HMRC come knocking and say, well, how do you go about due diligence? You're not scratching around trying to find out who's been doing what, but you've got a policy. You can say, well, this is our policy, this is what we do. And perhaps it's being reviewed by a professional to say, yes, this seems like a sensible policy. So I'd say that's point number one. Point number two is follow the policy. Because I've seen I've seen instances where there's a very nice policy on paper, and HMRC go, brilliant, right, let's see that, and that, and it's not all there. And then HMRC can hold that against you. They can say, well, look, you set up this policy, you went to that effort, and you didn't even bother to follow it. That suggests you're not interested in due diligence. And then they then use that for all manner of things, for example, to try and disallow your input VAT if they've discovered fraud down the line, CIS problems. So it's very important that you can show you followed it. And how do you show that? That's point three, which Pandy has emphasized several times, which is keep records. The number of times I've spoken to a client when we're trying to put together our evidence for a tribunal, and they say, well, we did do that. I say, great, where's the evidence? And they say, oh, we just looked at it on the computer screen. Right? How are we going to prove that to a tribunal? That's the difficulty we have, because HMRC is skeptical and the tribunal is skeptical. And the fact that you say, oh, I looked at this credit report, but I didn't print it off because I wanted to save the environment, the tribunal's entitled to say, well, actually, we don't think you did look at it at all. So keeping records, keeping proof that you did do it, a file for each customer, a file for each supplier, showing all the due diligence you did. I think that's essential. There's no point in doing due diligence. Well, there is, but there's no, it doesn't, you don't take it to the right degree if you don't keep a record, because when HMRC come knocking, you'll be found wanting. So I think the fourth point is to make a deliberate decision to assess what you've found. And this is again where a lot of companies fall short, because they may have gathered together a number of documents and say, well, that's our due diligence. And then you say, well, did anyone or any group of people stop to consider what this documentation actually shows about the company? And they go, oh, yeah, someone considered it. But they say, all right, well, this company was incorporated 3 months before you started trading with it. Did that surprise you? Oh, well, you know, and then it becomes clear they didn't really assess it. And then you look at things, well, they had 0 credit rating, and the director was also director of a failed company, et cetera, et cetera. So there's no point in having a folder of beautiful due diligence, a beautiful due diligence policy, and nobody's actually considered the result, because that's actually the key stage. That's the key stage for you protecting your business, is should we be dealing with this company? Are we taking a risk, a disproportionate risk by trading with them? And you can only do that when you analyze what you've managed to obtain by following your policy and getting the records. The fifth point is your supply chain. So it's very easy to, well, it's obvious to look at your immediate customer and your immediate supplier, but HMRC often expect you to have gone further. Now, that can be commercially very difficult, and the tribunals and courts do understand this, in the sense that if I know who my supplier is, I'm going to cut them out. So that can be difficult. But where possible, look for opportunities to investigate your supply chain and do due diligence on that. In fact, in some instances, the existence of a supply chain might concern you. So, for example, if it really is just supply of labor, whereby, for example, let's say you're a construction company and you don't want to hold the workers on your own payroll, so you feed them off to another company. It would concern me if I found out that actually that company had moved them on to another company and there was then a supply back. I would want to understand why on earth there are 2 companies in this chain. I would have thought the payroll company would just engage the workers and supply them directly to me. But that's what you tend to find, or often find, in these VAT fraud cases, is actually there's a supply. There's a chain of supply of labor even before the person supplying to you. And so the very existence of a supply chain can be an indicator you need to be aware of. And then the 6th point is, as Pandy referred to, contracts. And I've seen HMRC have always pointed to contracts. And what they like to say, for example, is, oh, there was no contract, no written contract. You're entering to transactions worth X 100,000 or X million with no written contract. That's not commercial. I mean, the clients I've spoken to tell me actually that might well be just how it works in a particular industry. But HMRC don't accept that. And to be honest, the tribunals have been very skeptical of that. So having a contract, a written contract for all your transactions is, I would say, a really good idea. But not just any contract. And this is again where I've seen clients fall down. You've got to read the contract, because if you do supply HMRC with a contract, you know who will read it? HMRC will read it. And they'll go through and they'll look for anything that suggests this is just what they like to call window dressing, something you just put in place without really caring what it says. So it's no good having a contract, so one you found on the internet, and just assuming that'll do. It needs to be a contract that actually deals with your situation and your supplier, and that particular supplier and that particular customer. And that I mean, I would say often requires the involvement of a professional. So I mean, I've seen agreements that turn out to be called data processing agreements, and HMRC were like, "Is this really your contract to supply, a data processing agreement?" And that's difficult to explain, isn't it? So taking that seriously, the contract seriously, it's good for you from a legal perspective, because let's say something does go wrong, you can try and protect your own rights. Say the VAT goes missing, you want to be able to sue someone. Well, deal with it in the contract. You can also deal with due diligence in the contract to some extent by requiring them to give you warranties that they've done X, Y, and Z on their own suppliers or customers. So the contract can be a very important focal point, and I've seen HMRC rely on that quite heavily alongside what they say about your due diligence. So in terms of due diligence, I would emphasize those points. And then just on this CIS grouping, I mean, the point I think you need to be careful there with is exactly what legal basis are you relying on to try and transfer these credits across? Because the ordinary way it works is that it's the company who suffers the deduction that then gets to set it off against their own payroll and similar taxes. So if someone's trying to tell you you can switch it between group companies, they need to explain to you very carefully exactly on what basis they're doing that. And frankly, you'd expect to see something about that in HMRC's manuals if it was permissible, because the HMRC have quite detailed manuals on construction industry schemes, and if it's not there, that should at least raise a concern that you need to take some independent advice, and that's an important feature of HMRC's policy and thinking in recent years is the need for independent advice. So if someone comes to you trying to sell you a scheme, relying on their advice won't necessarily give you a reasonable excuse if the advice turns out to be wrong, because HMRC will say, well, that person, you should have known, had a clear bias, a clear interest in the transaction. What you needed to do was go and take some independent advice on whether this was a good idea. And why is advice important? And this applies at all stages of what we discuss today. Advice is important because if you reasonably rely on someone you believe to be a competent professional in relation to that area, then that can, depending on the circumstances, provide you with a reasonable excuse, which may mean you don't suffer any penalties. Whereas if you can't point to that, HMRC may well decide to impose penalties for example, carelessness, which can be up to 30% of the tax involved. So having independent advice that's considered your particular circumstances, all the facts of your particular circumstances, and said, yes, we think this is a runner, they won't necessarily guarantee it works, but they say we can see that this has a sensible basis in law. Having that advice and relying on that advice is really important when it comes to dealing with HMRC. But yeah, thank you very much, Pandy. That's what I would add.
Thank you so much, Michael. I really appreciate it. Can I just pick up on the last point? I think it's a really important point from the CIS scheme and the offsetting of liabilities. Of course, as we said, and I echo that it is important that you look at the legal and the accountancy basis for any new scheme that comes out. But I suppose really the important bit is, as you mentioned, the carelessness of 30% potential penalties. Of course, you could have deliberate, couldn't you? And then, if you can add a few more words on the deliberate side, because of course we have got cases every day where HMRC say these are deliberate actions, and that of course got different components, not only the penalty, the interest component, and so on. So anything else you can add, I think would be very interesting for our attendees.
Yeah, well, I have seen HMRC take a more aggressive approach on deliberateness in recent years, in the sense of alleging it in cases where, for example, they think you just turned a blind eye. So if something seems too good to be true, and you didn't really question it, and you just went along with it, then there's a risk that HMRC may say, well, actually, you just turned a blind eye to this. It doesn't work, and we think you behaved deliberately. Something else I've seen them do is to accuse the agent you've relied on in relation to your tax affairs of themselves being deliberate. For example, if someone sells you a scheme and helps you implement that scheme and do your tax returns, and HMRC decide, well, that person knew this didn't work, then they can rely on that person's deliberateness, not usually in relation to penalties, but in relation to time limits, for example. And that's another important point, because people, let's say you do a scheme and then HMRC come along some years later and say, we think that scheme doesn't work. Usually there's a limit on how far they can go back. And if in a normal case, that might be 4 years, in a careless case, that might be 6 years, but in a deliberate case, it can be 20 years. And so they can rely on the deliberateness of your advisor to extend how far back they can go. And you can imagine that coming out of the blue, that HMRC can go back for a very long period, is a very, very big and nasty shock.
Thank you, Mike. I think that's the point really I wanted to catch, because we got one of the cases, as you probably know, where HMRC are going back to using deliberate concealment or deliberate act. And now they're going back to 1996, I think. It's a very, very, very long time ago. And I think it's important that whatever the scheme that, that are prevalent that people are taking, it's not just for now, it's not just for 6 years. And of course, it has that long-reaching component, both, as you know, from the tax point of view, but and also from a civil recovery, asset recovery point of view. Process Crime Act also gives that 20-year power as well. And I think that's worth remembering. Sonia, that takes us to 3:45 exactly. And I'm conscious everybody's busy with their schedule. So if there are any questions, of course, we can deal with it. Otherwise, I'll leave you to close.
No, that there's no questions. So hopefully everyone's been enlightened over the last 45 minutes, and it's a lot of food for thought. I think there's a lot for everyone to think about. And thank you ever so much to Pandy, to Michael, and to you all for attending. And we look forward to seeing you next month for the next webinar.
Very much. Thank you, Sonia. Bye-bye.
Bye, everyone.
Thank you, Michael.